8 o'clock. But obviously, just depending on the questions and how we work through it, maybe it'll be a bit later. After we've done the, I don't know what you want to call it, the mini presentation, I've got a couple of mock questions from the exam site that we can work through and maybe just have a bit of fun with that. So that'll be right at the end. So if you do have to run off, you're more than welcome to. I'll try and stick as close as I can to our time schedule, because I know that obviously time at the moment is very, very short. But yeah, let me jump into this. If you have questions as we're going through, just raise your hand. And then when I get a break in between, I will see if I can jump to the questions. All right. Okay, so the first thing we're going to talk about is the way succession happens. So there's three specific ways that succession can take place. Let me just... All right, guys, if you can just keep your mics muted while we're doing this, it will be perfect. Thanks. All right, okay, so the three ways succession can take place is testate succession. That is where a person has a will. We have intestate succession. This is where a person doesn't have a will. And then we have like contractual succession. You'll remember from family law, you can have a clause in your antenuptial contract where you can talk about the succession and how your estate would devolve. But those are the three main ways that you will have a succession. They do list what they would call a couple of ground rules with regards to succession. So the obvious one being the person has to have died. That pretty much seems like an obvious rule. I see we've got a hand up already. You can't have a question so soon. I've only just started. What's your question, man?
Hi, Darren. I'm sorry for noise. Do you mind sharing the screen?
I don't have anything at the moment to share. At the moment, unfortunately, I didn't do any fancy slides or anything up for this module. So I'm just literally reading off some hand notes that I've got. Unfortunately, I was a bit pressed on time to do something for this module, so I actually wanted to make up a couple of slides, but time just ran away from me. I only ended up finishing making a couple of notes this afternoon. So unfortunately, maybe next time I'll see if there is enough time to make some fancy looking slides. But yeah, so I'm just reading off the couple of notes that I do have. So if I do jump around a bit, that's probably why. But anyway, so with regards to succession, the person has to have died. There are two exceptions to that. The first one being that you have estate massing. That's where they have like a joint will where they say on the first dying spouse, both estates will devolve. I'm not going to go into that at the moment because we do discuss that further down. But the other exception is for a presumption of a death. You'll remember from PVL2602, they talk about if a person's been missing, you can go and seek an order from the court to declare that person to be presumed dead. So obviously, if a person, if they're not physically dead and you can't see them, they can be, or the two exceptions would be the estate massing and the presumption of death. When it comes to the transferring of rights, there's two terms that they talk about quite a lot that I've noticed in the prescribed book, and that is these two Latin terms that I was chatting about earlier. Now, my Latin is not very good, so you'll have to bear with me. But the first one is decedit, which literally means, the day will come. So this is talking about a right that gets vested now, but you don't actually have ownership of that right unconditionally until a future time. And then the complementary one to that is the dies venit, which means that literally the day has come and you now actually have that right to whatever it might be, the asset, etc. So those two terms, they get used a lot. I don't know if I explained them very well, but there is a nice little explanation in the prescribed book where they go through all the definitions. At the time that you get decedit, this is the part where you gain the right to inherit. The person must be alive or they must be conceived. For instance, a nasciturus fiction. So if a person has died, they can't inherit because a deceased person can't inherit. So we do need to remember that the person has to be alive. And there are a couple of questions in the mock exam where they do ask this sort of thing. They throw them in there as sort of red herrings. And the other thing to inherit is the beneficiary must be competent to inherit. So they've got to be alive and they've got to be competent to inherit. I'm not going to talk about the competence to inherit now because we'll cover that quite a bit more in depth a little bit later. But let's jump into the interstate succession. So this is where a person dies without a valid will. So then we now have to follow the Interstate Succession Act, which tells us it's a statutory way for us to devolve that person's estate. Who gets what, how much do they get, when do they get it, and so forth. You can also die interstate if you had a valid will, but it became inoperative for some reason, or perhaps your valid will doesn't dispose of all your assets. Maybe you bequeathed something to someone, they're not around anymore, so that would fall perhaps into the residue of the estate. And if you haven't said who needs to get that, that will then devolve via interstate succession. You can also, perhaps the person left a will that they intended to be their will, but it's got a defect somehow and the court can't condone it. In that case, the person is also dying interstate and it will follow the rules for interstate succession. So I'm not going to talk too much about the customary law system that is covered in the book. The prescribed book seems to focus mostly on interstate and testate, so I'm going to follow a similar sort of process. So I'm not going to cover too much on the customary law side of things, other than to say that how do they decide? Do you do the common law or customary law? What they'll normally do is they'll look under what system you live. So if you lived under the common law system, you will follow the Interstate Succession Act. But if you lived under customary law, you will then follow the Reform of Customary Law of Succession Act. So depending which one you lived under will depend what set of rules they will follow. But as I say, I'm not going to get too much into the customary law side of things. If you are interested in that, you can read that up in the book. All right, we were talking about capacity to inherit. There are a couple of things you need to, well, I had to make notes of for the interstate inheritance. The first one is that only a natural person can inherit. So for instance, juristic entities, which will be like your companies, your trusts, your associations, things like that, they cannot inherit. Only a natural person can inherit. With regards to children, whether they are born of married parents, unmarried parents, if they're adopted, if they come from a surrogacy, an artificial fertilization, anything along those lines, they are still allowed to inherit from their parents. So if you get a question that says, so-and-so was adopted, check that out. That's a red herring. They're trying to get you off the track. Just remember that an adopted child can inherit the same way as a normal biological child. Or if a child is born of unmarried parents, they can also still inherit the same way as a child would who was born of married parents. So just be careful. I've seen a couple of questions where they try and throw that out there to try and derail you. But just remember that children can still inherit from both parents, regardless of whether they're adopted or from unmarried or married parents. With regards to the succession order, there's a couple of rules that they've placed out there, and it is important to remember how the estate devolves. So when a deceased person is survived by a spouse or more than one spouse, but they don't have any descendants, there's two possible ways that the estate can devolve. So if the deceased is survived by one spouse and no descendants, the spouse will get everything in the estate. But if the deceased is survived by more than one spouse, what they'll do then, and same case here, there are no descendants, so it's just, let's say there's two spouses. They'll divide that estate out in half and each spouse will get half. If there are three spouses, four spouses, etc., they'll obviously divide it out by a number of spouses they have. Now, the reason I'm mentioning these here is there are a couple of questions that do deal with how does the estate devolve. Same with the calculations. There are a couple of them where they talk about the accrual and how much does each child portion, etc., get. So you do need to be familiar with how does the estate devolve depending on are there descendants, is there a spouse, are there parents, and so on. So just very quickly, just to read over the section, I'm not going to go into too much depth because you can follow this up in the book, but I just do want to highlight that there are different rules for the different, I'll call it, let's say, succession paths depending on who's still alive. So if the spouses are allowed and there's no descendants, the spouses will get everything and divide it up amongst them. If there's no spouse, but you've got descendants, what will happen is the descendants will inherit everything in equal proportions. And what's important to note here is if one of the descendants, let's say we've got John. John has two kids, Mary and Sarah. Let's say Mary dies and Mary has a child. Mary's child will actually inherit her share via what they call representation. So as long as one of the children has their own children, even if they die, they can still inherit. They call them, I think it was the Stirpes, if I'm pronouncing that right. It's when a person can inherit even if their parents have died. So if you see a question where they say, we've got three children, child A died but left two children, just remember that they can still inherit as well. With regards to the spouses, there is a note that I've just made here that you must remember that when you're calculating the estate that has to devolve, don't forget that the deceased spouse is entitled to 250,000 Rand or a child's portion, whichever one is the larger amount. Now, I know the prescribed book mentions 125,000. I was just as confused when I first read it, but that amount has actually changed since the prescribed book was written. The new amount is 250,000. So just make a note of that when you are doing your calculations. And just remember that the surviving spouse will get the larger portion of either the child's share or 250,000, whichever one is the greater one. So when you're doing the calculations, don't forget to calculate the child's portion first. If the child's portion is less than 250,000, that spouse will get the 250 first, and then whatever's left in the estate afterwards, we'll divide that out amongst the descendants, etc. There are a couple more ones where they work out, if it's survived by a spouse or parents, etc. I'm not going to read through all of those ones here because I think they're going to take up quite a bit of our time, but I do advise you to read through that particular section because there's quite a bit of information there, and it is important for when you calculate devolving of the estate. Now, when I say devolving, it's a fancy word that they use to say divide out the estate. With regards to another component of inheriting, a person can be disqualified or they could repudiate. So repudiate is a big fancy word to say that they don't want to accept a benefit from the deceased estate. So a person can be disqualified for various different reasons. For instance, they murdered the deceased, or perhaps they are a prodigal or something along those sorts of lines. There are certain disqualifications that can make a person not able to inherit. And then obviously, if a person chooses themselves, I don't want anything from this estate, I don't want the benefit, they can do what they call repudiation, which means they don't want to accept any benefit. What's important as well is if a heir is disqualified or repudiates his or hers inheritance, it can move down to their children if they have children. So let's say we've got Sarah. Sarah is entitled to 100,000 Rand as an inheritance. She says, you know what, I'm repudiating it. I don't want anything to do with my parents' estate. Just because she repudiated it doesn't mean that her children can't inherit. What will happen is the law will assume that Sarah has, for purposes of succession, has died, and that money will then transfer down to her children and they will share that money out. So if someone gets disqualified or if they repudiate, not accept the inheritance, it means that it will carry on to their children, assuming they have children. If they don't have children, whatever they repudiate, whatever they decide they don't want, is going to go back into the estate and will be divided out amongst the other heirs. So in other words, everybody else will get a bigger portion of it. That's pretty much all the notes I have for interstate succession. I don't know if anyone had any particular questions with regards to interstate succession. Maybe we can go through them now. Otherwise, we can jump into the testate succession. All right. It doesn't look like we have any questions for that, Sarah. Perfect. All right. So the bulk of my notes is actually to do with the testate succession in comparison to... Juliet, I see your hand is up.
Yes, hi, Darren. I'd like to ask, in an event, if there's a interstate will, then the deceased died and there's no descendant, there's no spouse, there's no parents, will I be right when I will be saying that all his estate will be given to the state?
Okay, so when you die interstate, the state is not going to get anything unless they can't find anyone to give it to. So what will happen is, so what will happen is if a person dies without children, without a spouse, and without parents, what will happen is that person's estate will be what they call cleaved. So half their estate will go to their mother's side, and the half estate will go to their father's side. So even if their mother and father are dead, they'll then go and say, right, did the mother have any children? If the mother had other children, they will inherit. The same for the father. If the father had other children, they will inherit. If the father didn't have any, then it goes to the next in line, and they'll keep going along until they find someone who's the next closest kin, and then that person will inherit. But obviously, if there is I suppose, a hypothetical situation where the executive of the estate could find absolutely no one, they traced everything they could, they did everything they could, I would imagine at that point it would become forfeit to the state. But I mean, I suppose the chances of that happening are very, very, very small, I would imagine.
All right, thank you so much.
I'm just popping over to the chat quickly. I see someone posted a question. It says, does a child of an adopted person inherit from their parents if they died interstate? So yes, they will inherit. So as I was mentioning before, they will inherit the same as they would with a biological child. So remember, when we were doing family law, when a person adopts a child, for all intents and purposes, for all legal reasons, that adopted child becomes as if it was their biological child. So they have all the same rights as a biological child. That adopted child will be able to inherit in the same proportion as any other child. Hey, Kunda, how are you doing?
Good evening. Am I audible?
Yes, we can hear you.
Perfect. So I just wanted to add on Juliet's inquiry about the no interstate heirs to the deceased estate. So what happens is the estate goes into the guardian's fund for a period of 30 years. And if no one comes to claim the estate, then it goes to the government. So it's just a key point, 30 years, guys.
Yep, so there you go. Eventually it will end up going to the state, but obviously there is a process involved. And 30 years is quite a long time. I'm sure someone must know someone by then. You know, I get a lot of these emails from these Nigerian guys. They must be right. Hey, they're knowing something I don't. All right. Are there any other questions with the interstate side of things before we move to the testate succession? I see a hand just gone up. Mado Ping, I'm not sure if I'm pronouncing your name right there. You'll just have to unmute your mic when you want to talk.
Yes, thank you, Darren, and good evening, everyone. I just want to confirm that I understood repudiate correctly. We are saying technically it's to disqualify someone from benefiting. And then if I am one of the spouse or descendant, I am deeply involved in the killing of the descendant, automatically I'm disqualified from benefiting anything from that particular estate. My children can come forth and say, because our father has been disqualified, we want to equally benefit what he stood to benefit from this estate.
Right. So what will happen is that person would be disqualified, but their children wouldn't. The benefit would pass on to their children.
All right. No, I think I understood correctly. I just wanted to confirm because when I read through it, it said if you are disqualified on the basis that you have been involved in the killing of the deceased, automatically you're disqualified. So I assumed that it disqualifies you and you're together with your children.
Well, the way I read it in the prescribed book there, they were saying that the person obviously who did it themselves, they are disqualified, but it doesn't disqualify their children. There was a case that they chatted about in the book where that actually happened, where he murdered, I can't remember if it was the parents or whatever it was, and then his child actually ended up getting the farm or something along those lines. So it doesn't disqualify the children, just the person who actually committed the offense.
All right, noted. Thank you.
Perfect. Danielle, I see your hands up.
Good evening, Darren. Excuse me, and good evening, fellow students. I just have a question regarding the vesting date for interstate succession. Do you know or are you aware that there are any questions going to come up in the exam relating to that? Because I know there is differences in terms of when interstate becomes applicable at the time of death or when the will becomes inoperative as the result of it being found invalid. So I just wanted to know if you've got maybe some insights on that topic, specifically to vesting date.
Sure. I haven't seen any questions asking that, but obviously I can't guarantee that the exam won't have questions. But in all the past papers that I've seen, I've never seen them asking that particular one with regards to vesting. What I have seen them ask is normally that Dies Cidet and Venit. They normally ask that question. So when does a person get the right unconditionally, and when do they actually claim the right? I've seen questions for that one, but I haven't actually seen a question with regards to vesting, and especially when a will becomes invalid, does it go from the deceased date or from the date that it became invalid? I haven't seen anything, or at least myself, I haven't seen anything, but obviously I can't guarantee that the exam won't have anything about that.
Of course, Darren. Thank you for that.
Cool. Perfect. Hey, Irene, how you doing?
I'm doing very well, and how are you, Darren, and the team?
Hey, I'm doing good, but I wish they could have pushed this exam back a couple more days. I need to sleep at some point.
I know. I can't wait for the 13th of November when I put my pen down just to relax a bit. Yo, it's been a tough time.
Tell me about it.
You know, Darren, I'm on night shift, but I'm not sure if you touched on this one already with the disqualification when they say, like, if I'm the descendant and I kill the deceased, so I'm automatically disqualified. But there was something where I read which says I might kill my mom, but if I'm insane, I still qualify for the inheritance. Like, meaning the fact of killing, it's not always quite disqualified. I can kill someone, but if I didn't have the intention and it was not for negligence, it is the condition that I myself am in, if I'm insane or those kind of things. So I still qualify. I saw one of the question in our mock exam, and I had to follow up on that one.
Right. I don't know a lot about that. The closest that comes to mind at the moment is the one where the court said that it's only the unlawful killing that would disqualify. But as I say, that's the only thing that comes to mind now. I'd have to go back and read a bit more on it. But I do remember there being a court case where the judge was saying that it's only the unlawful killing. But as I say, I'd have to go back and read a bit more on that.
Thank you so much for mentioning unlawful, yes. And then because if I find it again, I will send it on our group so that people can be check out on that one, because I saw it on our mock and I followed it up. Yes, if I'm insane and I kill my parents or whoever that I'm supposed to inherit from, and I'm insane, I still qualify. But I will follow up, and then I will alert the group.
Oh, cool. No, 100%. It'll be good to follow up on that, because the only thing that's coming to mind at the moment was that court case where they said that it was the unlawful killing. So it'll be good to follow up on that if you do find it.
Thank you so much, Darren. Thank you.
No, 100%. Have fun at work.
Yes.
Temba, I see your hand is up. What you got for us?
Good evening, and thank you very much for this beautiful session. But I have a suggestion that I'm mindful of the time that you see, if we start barraging you with questions at this moment, you might not be able to finish the notes that you might have prepared for us. So what I'm suggesting is that can't we then maybe give you enough time to maybe present the whole notes that you have for us, and then at the end of the session, then we can maybe, if there's still enough time, ask questions. Just a suggestion.
All right, we can try that. I do have quite a few notes, so maybe that is a good idea. Maybe we can try and get through as many as we can before we do questions. I know I normally let the guys ask questions in between because sometimes you might forget. But yeah, maybe we can try that just for time's sake. I'm just reading a question in the chat quickly. It says, is it correct to say that if an interstate heir repudiates a benefit, that it will accrue to the surviving spouse? However, if the interstate heir is disqualified, it will devolve to the heir's children. Yes, that is correct. Let me just see if I've got it here quickly. Okay, so okay, yes. So if the person is disqualified and they've got descendants, they will inherit from that. But if they aren't any go to the other heirs. But when it comes to repudiating an inheritance and there is a surviving spouse of the deceased, that surviving spouse will indeed get that part of the inheritance. But if there is no surviving spouse, then that benefit will go to the heir's descendants. So you are spot on with that. All right, so okay, let me just jump into the testate succession so long. We'll go through that one. Okay, so we've done interstate succession. That's where a person doesn't have a will, and then we've got to follow the Interstate Succession Act. But if a person has a valid will, we can then follow this process. So this is called the testate succession. It's when the deceased estate is devolved according to their will. So they get to decide how the estate is devolved. For there to be a valid will, there's certain formalities that need to be followed in making and executing that will. So executing means when he signs it and you've got the witnesses and the commission of oaths if need be, and so on. That's the whole process of executing the will. The basic requirements for a will is that the testator, that's the person who's making the will, they must have the intention to execute a will. They call this the animus testandi. In other words, there must be the intention of the person that this is going to be a will. It can't be, oh, I'm just joking, I'm writing this down. It needs to be, this is a will and I'm making the will. So they need to have that intention to make the will. The second requirement is that it needs to be done voluntarily. The third requirement is that the person doing it must have testamentary capacity. In other words, they must be legally able to make a will. And the last one is the will must comply with the formalities of the will. That's one where we've got a signature and witnesses, etc., etc. I'll cover that further down, but those are the four main ones. The person needs to have the intention to make a will. It needs to be done voluntarily. A person needs to have the capacity to make that will, and the will must comply with the formalities for making a will. All right, with regards to the intention to make a will, they call it the animus testandi. Very nice, fancy Latin word, but just remember, if you ever see that it means that they're talking about the intention to make a will. I see someone has their mic on. If you can please just mute your mic, I'd appreciate it. Okay. Okay, so if the person doesn't have that intention to make a will, that animus testandi, the will be void ab initio. So from the get-go, that will doesn't exist. Other things that would make a person not have the intention of, for instance, a mistake. The person didn't know they were actually making a will. They might have thought it was something else, or maybe they thought it was a joke, you know. I think the book uses that example of they're in a pub and as a joke he writes, you know, his so-called will down. Or perhaps there was force involved, or undue influence, things along those lines. All of that will then void the person's intention to make a will. With regards to undue influence, there is a caveat though, because it depends on the influence. The courts have in some stages said that, you know, undue influence isn't a problem, but in other times, because of the amount of influence, because of the person's thinking and the time between when the influence happened and the change, in some of those cases, they have said that that is a problem and they voided the will. So undue influence, you've got to look at the rest of the circumstances with it. It's not just a a fiat accompli, it's not a valid will. It depends on those particular circumstances. I haven't seen any particular questions on that as of yet, but it is something just to keep in the back of your mind, that undue influence doesn't automatically invalidate a will. So that's to do with the first part, the person's intention to make a will. The second one is the voluntary component of it, the volition. They've done it of their own free will. So they need to make sure that there is no undue influence. And I've actually got the case here where it talks about Spies v. Smith, where they said that, for instance, there's nothing improper about a person using flattery or declarations of love, etc., to try and get a person to put them in their will, for example. Also, being in a relationship with a person isn't enough to indicate that there's undue influence, but they obviously do take that into account with other things such as the person's capacity to withstand pressure, the amount of time between when the influence was exerted and the execution of the will, etc. So that will all fall under the person's freedom or volition to create that will. Was there undue influence? Is it something they did freely? Were they under duress? Were they forced to make it? So that will all fall under the volition component. The only thing we really have to remember for that is they must have done it of their own free will. I think that's pretty much all we need to cover on that one. There is a note I see in a bit more than a note in the prescribed book, where they talk about codicils and testamentary writing. And there are some questions that do ask about what is testamentary writing. So I've got a few notes on that one because I have seen a couple of questions that ask it. So the Act says that in addition to a will, that testamentary writing and codicils all qualify as wills. So what is a codicil? So a codicil is an amendment to a will without having to go and rewrite the whole will. So it's like, in my words, I would call it an addendum to a will. So a person executes a will, but then they say, oh, I want to change it. Oh, I don't want to go and rewrite. I don't want to go and write on the will. So I'll just draw up another addendum, using my own words, to say that, what, I said John could have 10,000, but I want to make it 20,000. So I write up a new thing saying, as per my will, I want John to have 20,000, not 10,000. And then you execute that. And that would work as an amendment to the will. Just bear in mind that when you do a codicil like that, or an addendum as I call it, it needs to be executed as per a will. So it's the same rules. You need to have two witnesses, and it needs to be signed. And if you're not signing, it needs to have a commission of oaths, etc. there. So just remember, it has the same formalities as a will. Then they have what they call testamentary writing. So these also have to comply with the Wills Act, but these are documents that fit into one of the three, let's call it, elements of a bequest. So they will, for instance, identify the property, which could be, for instance, a photograph of the asset or a drawing or things along those lines. It describes the extent of the interest being bequeathed. And in other words, are we giving ownership? Are we giving a fidei commission? Are we giving an usufruct, a temporary use of it? So that will also be part of it. And the third element is the identity of the beneficiary, so the person to whom this is due. So that will all fall under what they call testamentary writing. And obviously it has to follow the same requirements as a will. Otherwise, they don't normally accept it. So all of that falls under codicils. This is just merely a very quick snapshot of the main parts that I found interesting and I've seen in questions. The other thing they talk about as well is joint wills. I've only got two notes here for you. A joint will is when there are two or more testators. Remember, these are the people that are making the will. They set out their respective wills, but all in the same document. So it's a joint will. Maybe they're trying to save on costs, the attorney costs money, etc. So we'll draw it all up together in one document. That would be called a joint will. Then they have what they call a mutual will. So this is where two or more testators, that's the people that are drawing it up, they have a joint will, but it also confers benefits on each other, which is why they call it a mutual will. So inside a mutual will, each person's part of the will, if you want to call it that, is seen as a separate will, and they each are allowed to unilaterally revoke or amend their own parts of it. But the difference between a mutual will and a joint will is a mutual will means that they're conferring rights and benefits on each other, whereas a joint will is just individual wills that aren't related to each other. Those are the only two notes that I've got for this particular section, because we just need to remember there's a joint will and there's a mutual will and what the difference is. So just to recap, a joint will is just a single document that multiple people have put their wills into, and they execute it all at the same time. And a mutual will is the same thing, but the difference being that the people involved in a mutual will are conferring benefits on each other. So they might be saying, for instance, when I die, you get my entire estate, or vice versa, etc. With regards to adiation and repudiation, adiation refers to accepting a benefit, and repudiation refers to not accepting a benefit. I'm going to try and stick to using those two words because they do use it quite a lot. And also the mock exam questions, you'll probably find the actual exam questions are going to follow the same thing. They may say accept a benefit, but there may probably be a high chance of them saying they adiate the benefit, or there's adiation involved, etc., or repudiate the benefit. So repudiate is I don't want it, you keep it, I don't want anything to do with it. And adiation meaning that I accept the benefit. What's important to know for our law is that no one is obliged to accept or reject a benefit, and there's no formalities required if you want to adiate a benefit. So adiate meaning accepting a benefit. There's no special requirements. However, if you want to repudiate a benefit, in other words, I don't want the benefit, usually this has to be done in writing, because most people, or the thinking is, most people will accept. So if a person rejects it and doesn't want it, we need to have that in writing just to make sure that we're all on the same page, sort of thing. Following in with the adiation and repudiation, they have what they call the doctrine of election. So this is where there is an obligation attached to a particular benefit. And when this happens, the beneficiary needs to elect to either accept this benefit, knowing that it comes with obligation, or to repudiate that benefit. If the beneficiary accepts that benefit, so if they adiate the benefit, they've also got to accept the obligation that comes along with it. It's not possible that they can adiate partially. In other words, they can't accept partially. The benefit has to be accepted in a whole, so it comes with all the strings attached with it. If the beneficiary elects to not accept the benefit along with the obligation, then that beneficiary can't receive anything under the will. But bearing in mind, this only applies when there's an obligation tied to that particular benefit. If there's no obligation tied, then there's no need to elect. But if there is an obligation tied, so for instance, John dies and he says, hey Darren, I'm going to give you my speedboat, but you need to give your brother 10,000 rand. Well, there's an obligation attached to that. So in order for me to accept it, I've got to now, accept the obligation that comes with it. And if I refuse it, then obviously I lose all of those benefits. One more note with regards to testamentary capacity. So testamentary capacity is talking about the legal capacity for a person to make a will. You've got to be 16 years or older in South Africa when you make that will up. And you also have to obviously be mentally capable of understanding the nature of what you are drawing up. With regards to witnesses, you have to be 14 years of age to be a witness. And there are a couple of questions where they'll ask you ages. I haven't seen too many, but I mean, it's easy enough to remember. You need to be 16 years of age in order to make your own will, and you've got to be at least 14 years of age to be a witness to a will. Now I'm going to jump more into the formalities for a will. This section is quite bulky, but there are a number of questions, and even the questions that I've got for you guys tonight, there are a couple of them that will relate around the formalities to the will. So in other words, there are certain rules that we've got to follow for a will to be valid, otherwise that will is invalid. Requirements, for instance, are that the will has to be signed by the testator. In other words, the person who's making the will has to sign it. If the will comprises more than one page, then we need to make sure that every page, other than the last page, must be signed somewhere on the page by the testator, so that we know that this actually is his will, and that's part of the whole document. Because if you don't sign the page, then that page can't be accepted, because there's no proof that this is actually the person's will. The signature of the testator needs to be made or acknowledged in the presence of 2 or more witnesses. And they call them competent witnesses because obviously there's a certain age requirement, etc. So the minimum is we need at least 2 witnesses. We can have more, but the bare minimum we need is 2. When the witnesses are there, they need to attest and sign the will in the presence of the testator, so the person who's making the will. And where applicable, they have this omniscience, which is where the person signs the will on behalf of the testator because maybe he's infirm or whatever the case is and can't sign. That person will sign on their behalf. But we need to make sure that the witnesses are there when the testator is signing. If the testator has already signed it in advance, he then needs to tell the people, you know what, I did sign this in advance, but this is my signature and these are my initials, etc., etc. And then obviously the witnesses can sign. They are allowed to do that. So the testator, just to recap that section, the testator has to sign with his signature and he has to have 2 witnesses there. If a testator doesn't use his signature and he uses a mark, you then have to have, in addition to the 2 witnesses, you have to have the commissioner of oaths there to certify it. If you have the omniscience who signs for the testators, the testator must be there when the omniscience signs. You need the 2 witnesses and you need the commissioner of oaths. It's important to remember these 3 because there are questions that will ask about that, and we got some tonight as well. So the first one is the testator signs with his own signature. He only needs 2 witnesses. If the testator signs with a mark, so maybe it's his thumbprint or maybe it's an X or whatever the case might be, it's anything but a signature, he needs to have the 2 witnesses there with him and the commissioner of oaths. If the omniscience signs for the testator, he needs to then also have the 2 witnesses and a commissioner of oaths as well, who will then certify that everything's above board. There are a couple of questions that ask about written, typed, printed, etc. According to the Act, the will can be written, typed, printed, or any combination of that. The only thing is it can't be oral. It can't be in the form of a video. It can't be saved as a file on a computer or anything along those lines because it doesn't follow the formalities of a will, which is to have witnesses and signatures. They obviously can't sign a video, and a person doing an oral will obviously can't have that signed either. So that is a problem. So we need to remember that any will needs to be written, typed, or printed, or any combination of those, but they can't be videos, they can't be SMS, it can't be I heard someone say something. It's got to be written in some format. With regards to signing, there was a whole discussion in the prescribed book about what does signing mean. I'm not going to go through all of that. I'll just give you about 6 pointers that summarize that entire section. So when they say sign, what they mean is you're making a mark for the testator, but the witnesses can't use that as their signature. A witness has to use initials or a signature. Only the testator is allowed to make a mark. Under the Act, initials do qualify as a signature. So a witness, the testator, the omniscience, the commissioner of oaths, etc., all of them are allowed to use initials or a signature, but none of them are allowed to use a mark. The mark is reserved specifically for the testator if the testator wanted to use a mark. So that's pretty much that whole section summed up in like a couple of points. With regards to signing, I think I've seen maybe one question in the mock exam that asks this, so I'll just include it even for interest's sake, because maybe you're writing your own will and you want to know for yourself. But with regards to where you must sign, the testator must sign at the end of the will and needs to be as reasonably close as possible to the last paragraph. There was that Kidwell case where they were talking about the amount of space between the last paragraph and the signature. So we've got to make sure that there isn't too much space, or the court might say that it's not a valid will because of that particular requirement. I see a couple of questions. Okay, so the mock exam, I'll get all to those questions as soon as I finish this particular section. Okay, so with witnesses as well, I'm just going to go over that section again. They've got to be at least 14 years of age, and there are certain witnesses that are not competent. So for instance, you can't witness a will if you are going to be a beneficiary in the will, and that includes being an executor or anything along those lines. You can't also be a witness. there is a note in the book that that mentions from 92 witnesses don't have to sign every page, but I do know that they recommend signing every page, and witnesses have to sign after the testator is signed. So what I think I'm going to do is I'm going to leave all that out for now, because I'm pretty sure we can go and look it up later if we need to. But just remember that a witness can't benefit from a will. They will be excluded from benefiting. All right, commission of oaths we've done. Okay, so we want to amend the will now. So let's say we made a boo-boo, we made a mistake, and we need to now amend it. So the testator can amend the will at any stage that he wants to. So he can either execute that codicil, as we mentioned, where he does an amendment, or he can actually amend the will itself. He can do additions, alterations, he can scratch things out, he can do things on the actual will if he needs to as well. What has to happen, though, is he does need to, whenever there's an amendment on the actual will, so let's say he crosses out John's name and he puts Mary's name down, he needs to then, as close as possible to the amendment, he needs to sign for it, and the two witnesses also need to sign as well, so that we know that it's a legit amendment. If we miss any one of those ones, if the testator doesn't sign or if the witnesses don't sign, that amendment would be thrown out and wouldn't be accepted as valid. So do remember, we can amend the will, but we need to follow the same rules for the will. So it needs to have the signature for the testator and the two witnesses. And obviously, if there's a menesis that is signing for the testator, we need a commission of oaths stamp as well. My last note for that particular section with regards to the formalities was that sometimes there might be a defect in the will that's minor or can be condoned. The courts under Section 2.3 of the Wills Act allows them to condone a will if there is a defect. So, for instance, maybe I don't know, they forgot the one witness's signature or something along those lines, or there's a defective part to it, but it's not major. You can approach the courts, and they use this so-called rescue provision to try and rescue that particular one or particular will. If you want to read more about the condonement, you can go to look up Section 2.3 of the Wills Act, but I'm just merely making a note there. If you get a question that says, can a court condone a defective will? Yes, the courts can condone a defective will. There's a couple of rules, but I'm merely just making that note here, because that's quite a long section that you can read through. It goes through quite a lot of cases. The next important aspect was with regards to a revocation of will. So revocation meaning you're revoking it, you're cancelling it, you don't want it to be valid anymore. Important to remember is that when you revoke a will, it doesn't just come back to life if you cancel your current will. I know there were a couple of questions asking about that particular thing. All right, so we've got that one. All right, so, how to revoke a will. So they normally say you can destroy the document as a whole, or you can write across the whole document, cancel, revoked, etc. Or if you make a new will, in that new will, you can say, I revoke all previous wills, etc., etc. All of that will revoke the previous will. Right. Then the opposite of a revocation would be a revival of a will. So if you wanted to, let's say, revive a will that you previously revoked, so revoked will, it's no longer valid. If you wanted to revive it, you could execute it as if you did a new will. So in other words, get two witnesses and sign it. That would then revive that particular will, because basically we are reissuing it, if you want to call it that, because we've got the two witnesses and we've signed for it. There are 3 requirements that the SCA have included for reviving a will or re-executing the will. The 3 that are listed is number 1, the lapsed or revoked will must have been validly executed. In other words, it must have been a valid will before it was revoked. So it had to have the two witnesses, it had to have the testator signature, etc. The second requirement was that the lapsed or revoked will must have be incorporated in the current will, so that we all know that we are reviving that one. So they call it incorporation by reference. The last one was the testator must intend to revive that previous will. So it can get quite messy. Right, we'll skip that. Okay, capacity to inherit, I'll just briefly touch on this one. Capacity to inherit, you've got to be a natural person. if you're talking about interstate succession. If you're talking about testate succession, companies can inherit, associations, etc., because you can bequeath that company, that association, partnership, etc., with assets or whatever it is you're giving to them. Just remember that interstate can only be a natural person. Nascent jurisdiction, we haven't covered that yet. Nascent jurisdiction, if you remember from PVL2602, is a conceived but unborn child. So for purposes of interstate success or succession in general, if a person says that I devolve this on my children, and perhaps the wife has an unborn child, for the purposes of that unborn child be treated as if it was an alive child, and they will be entitled to that benefit. Obviously, bearing in mind that the child needs to be born alive or that benefit will fall away. So there are a couple of questions where they throw that in there, like so-and-so is pregnant. So I bequeath X amount of money to all my grandchildren, and then one of his children's pregnant. We need to remember that pregnant child is obviously carrying the grandchild. So just remember that nascent jurisdiction does apply to the law of succession. All right, we'll skip all those ones. Freedom of testation. So you can pretty much put anything you want in your will, so long as it's not illegal, against public policy. It can't be vague or uncertain. As long as it's nothing along those lines, you can put pretty much anything you want in your will. There are limitations. So, for instance, a fideicommissum, if you want to bequeath, let's say you've got a farm, I want to bequeath it to my eldest born son, but I also want him to bequeath it to his eldest born son and his eldest born son, and so on and so forth. There is a limitation on how much you can do that, and it's statutorily limited to 2 fideicomissions. So you can give it to your let's say, for instance, your eldest son. That doesn't count as the first one. He's the fiduciary, and then it gets handed on to his eldest son and his eldest son. That will count as the 2. There isn't a lot of questions. I think I might have seen maybe one dealing with this particular thing, so I don't think it's a hot potato. But just remember, if we are talking about a fideicomission being handed down, it's to a maximum of 2. All right, we'll skip all those ones. Okay, let's talk quickly on bequests. So there are 2 types of bequests. You get an absolute bequest and you get a conditional bequest. So a bequest is when you leave a gift or you leave something for someone. An absolute bequest is there are no strings attached. It's yours, have it, mahala, enjoy it. The conditional bequest is where there are certain obligations or rights attached to it. So for instance, it postpones the vesting of the rights, which may only take application in the future, or when something occurs in the future. So there's no guarantee that it'll actually happen. So an absolute bequest, nothing special. You get set it, desvet it. It all happens at the same time. The person gets their bequest, they're happy, they're off to the Bahamas. But you also get that conditional bequest, and it's based on something in the future that may or may not occur. And you'll notice it includes words such as if or should. So if this should happen, or should that happen, those are good indications that there is a condition attached to it. Here they talk about a resolutive/terminative condition and a suspensive condition. So a resolutive condition, which is a terminative condition, this is when the benefit will terminate. So you might say, I bequeath my farm to Mr. John. However, it terminates on the 19th of July, 2050. So that would be a conditional bequest because it's got a terminating clause in it. That person gets to use it up until that point when it terminates. You can then have a suspensive condition, which means nothing happens until something occurs. So we might, for instance, say that I leave my house to my son, John, should he complete and pass his LLB course. In this case, the son gets nothing until he completes that LLB course. Once he completes his LLB course, he then gets that right to his house, as an example. So that would be suspensive. In other words, easy way to remember this, suspensive, he's waiting in suspense. He can't wait to finish his LLB course so that he can get this condition out the way and he can accept his bequest. Tagging on with the bequests, they have that nudum septum, if I'm pronouncing it right. It's that Latin, very fancy Latin word. This is where the testator puts a condition on his bequest, but he doesn't allow for what happens if the person that's the beneficiary doesn't follow his conditions. What will happen to it? So, for instance, he might say that, you know, I leave my house to you so long as you don't leave the country. If you leave the country, it goes to John. If he just says that, I give you my house, don't leave the country, or you lose the house, but he doesn't say to whom or what's to happen to it, then he's got a problem. All right, I will skip the modus. Right, we'll go through all of that. All right, so I think we'll leave it there for now because I see our time is at 8 o'clock now. Are there any questions that anyone has with regards? I know it was very, very quick. We've skipped over quite a few things that I want to cover, but I think we've covered the main bulk of the important bits and pieces that I've found. Before we jump maybe into practicing the questions, did anyone have any questions with regards to the testate succession or any of those other topics we're talking about with regards to bequests? Oh, I see a hand up. Boitumelo, if I'm pronouncing your name right there.
Yes. Hi, everyone. Hello. I wanted to ask in regards, am I audible?
Yes, we can hear you.
Oh, I wanted to ask in regards to the joint will. So because it's two testators in the joint will, let's say one of the testators wants to make an addendum or a codicil, will it affect the other one, or they each have separate regulations in regards to their wills?
Okay, the way I understand it, to my mind, is because it's a single document and it's a single will, if they wanted to make amendments to it, they would then have to re-execute the will, meaning all the testators in that will would then have to re-sign, the witnesses would have to re-sign because it's a single document. I would imagine you could bypass that whole process if you did a codicil, so an extra, let's call it an addendum to that main one. But to my mind, if you wanted to adjust that main one that was a joint will with everybody else, in order to re-execute it or to do the amendment, I would imagine that you would need the witnesses, etc., again to certify that that's actually what happened. That's to my mind anyway.
Okay, thank you.
I see we have someone's mic is on. If you could perhaps switch your mic off for us.
Precious, mute, please. Precious, please mute. Thank you.
Perfect. Maropeng, do you have a question for us?
Yes, thank you, and greetings once again. It is in relation to the formalities of the will with regards to the signing of the testator and the witnesses. I just want to check if I have concluded my will and it has met all the formalities, and then I revisit the same will to say I want to amend one or two things in the will. Do I have to come with the same witnesses from before, or is it fine if I use any competent person to sign on the amendments? Thank you.
All right. Perfect. It's actually an interesting question. For the way I understand it, you can use new witnesses. They don't have to be the same as the other two witnesses, but as long as it's two witnesses, the way I understand it, you can use new people for that amendment. Madlingos. Oh, I'm messing up your name there. I see your hand is up. What's your question?
Good evening, Darren. Okay, my question is also around the formalities of a will. Now, I want to know, okay, I know that if you sign as a witness, you don't stand to inherit. But now, if you were just assisting the testator to just type the will, would you still not be able to inherit, or what is the story?
All right. From what I remember, where they were talking about that specific thing, if you were handwriting it, you wouldn't qualify as a beneficiary. But they had a note in there where they said if it was being dictated to you and you typed it, you would still be able to inherit as a beneficiary or accept a benefit from the will. But it had to be typed. It couldn't be written in your own hand, from what I remember about that specific topic.
Okay, thank you.
Timber, I see your hand again.
Yeah, my hand again. Okay, in terms of the cases, Darren, one would want to maybe have a way of approaching. Do we really have to try and memorize? Because I see there's quite a big chunk of cases. Or should we be approaching it in a different manner? How should we be going with? Should we be approaching that? If you have a tip around that.
Okay, it's the line is quite bad there, but from my understanding is you want to know what is the best way to approach this module for the exam. Is that how I understand you?
Can you hear me? No, I'm talking about the cases that are related.
Oh, the cases. Yeah, so the cases we're going to have to approach the same way we did for family law. We're just going to have to memorize those particular cases. Obviously, I can't tell you which cases they'll call up, but the same as we did for interpretation of statutes and family law, we're going to have to, some way or another, memorize that case. So we have to know that the Wilco one was this, or the Keith one was that, etc. Right. All right, perfect. Yeah, I don't particularly like to memorize some things, but I think when it comes to the cases, it's just one of those things where we've just got to remember, in this case, they were talking about whether a person could type the will or handwrite the will. In this case, was talking about what a competent witness was. So there are, unfortunately, those cases that we would have to memorize to a certain degree. Personally, I don't think we have to know everything about the case. We just need to know what was the outcome for that particular case. So case A was talking about who could be a witness. What they said was, if you're a beneficiary of a will, you can't be a witness, that sort of thing. I don't think we need to know every particular part about every particular case. I see your hand is up again, Boyd Trumelo.
Yes, I wanted to follow up on Madlingo's question. With the handwritten, if you are asked by the testator to read the will handwritten, and then will your son be able to inherit, or they're also disqualified from inheriting, as well as the person who's going to, the witness? Let's say the witness is the husband of your daughter, who you also said must inherit. Are they also going to be disqualified, or they're going to inherit? I don't know if I'm making sense.
Yeah, no, it makes sense. All right, so if the person is going to handwrite that will and it's going to be in their own handwriting, they won't be able to benefit, nor will their spouse be able to benefit. However, it shouldn't affect their children if their children are in it. It just means them and their spouse won't be allowed to inherit from the will.
Okay, I'm asking this because there was assessment that had a question like that, and they disqualified the son as well. So I wanted to make sure if that's the case.
Well, so the notes I've written down specifically from there was the people that are specifically excluded from inheriting is anyone that's involved with the execution of the will. So that'll be, for instance, the witness, the arminesis. If it's done in your own handwriting or anything along those lines, the executor, the trustee, the guardian, and any spouse. It doesn't say anything about the children of those people being disqualified. So I'm not sure if perhaps, I'm not sure with regards to the other question from the assessment, if it said that they also can't inherit or not, because I know from the prescribed book, they don't talk about the children not being able to inherit. It's just the spouse of that person not being able to inherit.
Okay, no, thanks.
But if you did have that in your assessment and it said that children can't inherit, maybe you could pop that on the group. I'd love to follow up with it, because I'd like to see why it's not covered in the book or vice versa, just to try and see what's what before the exam, so we don't get any surprises.
Okay, I don't think I'm in the same group as you guys. I just got the link by luck. I'm gonna send it now in this in the Teams.
Okay.
Oh, thanks.
Otherwise, I will drop the other link in there as well for those that want to join. Let me just see if I can grab it up here quickly. Otherwise, how are you guys with questions? Is there anything else with regards to that, or do you want to jump into doing some of the mock exam questions? I'm going to take quite being good. Oh, there we go. We had a hand. Go for it. What question do you have for us?
Hi, I hope you're doing well. So my question is, when it comes to witnesses, can you just pick strangers and not like any family member, just because if they're included, if they're witnesses, they won't be able to inherit from the will.
Yeah, so you're not going to want anyone that's from your... Oh, I see there is an echo. I'm just trying to get rid of the echo. Okay, perfect. There we go. All right. So you wouldn't want your family members to be witnesses to the will, because then they're not going to be able to be a beneficiary to the will, unless, of course, they were never going to be a beneficiary, in which case it doesn't make a difference. However, if it was myself and I was making a will, I'd obviously ask a friend or somebody else to be the witness to my will. Or if you're going to an attorney, they might be able to have a witness for you who can sign, might have the receptionist or whatever the case might be. But I mean, it's entirely up to you if you want your family members to be a witness, just bearing in mind that whoever's a witness can't inherit or can't get a benefit from your will. So I would imagine in most cases, you wouldn't want your family members to be a witness to the will, because then you wouldn't be able to leave them anything.
Okay, thank you.
Oh, perfect. Do we have any last question before we move on to the fun part? Actually, I think I saw a couple of questions in the chat. Let me just go have a quick look over there before we jump to the questions. Okay, yes, someone was talking about making a will. So yes, the age there is, if you're making a will, you've got to be 16 or older. If you're being a witness, you've got to be 14 or older. With regards to the recording, I see there's a question about that. I'll post it up on YouTube, and then I'll share the link in the WhatsApp group as well. If you are on the YouTube channel, if you are subscribed to it, you should hopefully get a notification, but I am posting it up on YouTube after we finish here, and then I'll share the link there as well. Right, I think that's all the questions that I've seen there. Perfect. So do you guys want to jump onto some questions or some Q&A questions from the mock exam?
Yes, please go ahead.
Yeah, I think this is the fun part, where we actually get to do something cool. I hope you guys brought your snacks. Let's see, I just want to share my screen. Where's the window? All right, I'm just telling Teams now to share. You can let me know once it pops up on your side, and then we can work through them. All right, I see a thumbs up. Awesome. Okay, so what I'll do is, for those that are working or not able to look at their screens, I'm just going to read the question out, and then we can see who wants to take a stab at answering it. All right, so the question is, which one of the following documents may not be accepted by a court as a will in terms of Section 2(3) of the Wills Act? So they want us to find out which one is not acceptable. Options are A document typed by the deceased on his computer before sending it by email to the beneficiary. Option B is a will drafted by an attorney for the deceased, which document was signed by the deceased, but without the two witnesses being present. Option C is instructions on how to draft the will given by the deceased to his attorney. And option D is a suicide note written by the deceased before he committed suicide. So out of those 4 options, which one do you think it is? Oh, we've got a hand up already. Go for it. Which one do you think is the correct option?
I'm gonna go with option B.
Option B. All right, we got a B. Oh, I see the chat's got quite a few B's too. Oh, and a brave D. Who else wants? I see Madebe.
Irene.
Now, I was trying to do your first name. I was trying to get it right, but apparently
Oh,
not. So it's fine. It's Irene it is.
Madimabe. I'm also going with a B, definitely. Yes.
A B. Okay, perfect. So we've got quite a few going for. Oh, no, I see the D's are now overtaking in the chat. Oh, we've got B's and D's. Who else wants to try and give it a go? We'll squeeze like one more in. Oh, we got another B. All right. So the answer for this particular one is option C. So it's instructions on how to draft his will. Does anyone, all right, I suppose, okay, so the reason that option C is the correct one here is because he's only giving instructions on how he wants his will to be done up, typed up. So in other words, it's a future event. He hasn't conceded to it or even seen it yet. Whereas option A, the person's typed the document and sent it, so from his computer. So obviously he's typed it himself, he knows what's in it. Option B is the will's been drafted and it's been signed. It was just a minor defect with regards to the formality, which is the 2 witnesses, which they'll ask the court to condone because the deceased did sign it. Option D is the suicide note that was written by the deceased. In other words, we're assuming here it's written in his own hand by him before he committed suicide. So the only option that stands out that doesn't fit into the others is option C, because it specifically says instructions given. And there was a case where they were saying that merely giving instructions to someone doesn't qualify for condemnation by the court. So if you do get this question or a similar question, just remember that if it says instructions on drafting a will, that doesn't count to be condoned by the court. Make sense? Let's try next one. Sure. Okay, this is quite a long question there, so you might have to, on your phone, if you pinch and zoom in, you might just have to do that to see, because the text is quite small even on my side. But the question is, how is an interstate estate divided if the deceased is not survived by a spouse, a descendant, or a parent, but is survived by descendants of both parents? Some of the descendants are full blood relations of the deceased, and others are half blood relations. Our options are A, the estate descendants of the father inherit equally. Option C is the nearest descendants of the predeceased inherit. Option D is the descendants of the predeceased parents inherit in equal shares. And my first hand up, it was even fast. Which option do you?
I'm gonna go with
You'll just
option.
have to unmute your mic there.
Can you guys hear me? Hello?
Yes, I can hear you there.
Okay, awesome. I'm gonna go with option A.
Which option do you want to go for? Okay. Oh, we've got a lot of A's going on in the chat. The A's seem to be winning. Nankululeko, I see your hand is up. You'll just have to unmute your mic if you want to talk.
The correct answer is A.
All right, does anybody else want to have a go? It seems like A is winning. All right, so if you chose
Guys, I don't know if it's just me, but Darren's losing connection.
Sorry, guys, it looked like we had a bit of a technical glitch there. Can you hear me at the moment?
Yes.
We can hear you now,
Yes.
Darren. Yes.
I think you're muted again.
Is he gone again or is it on my side only?
No,
I
it's
think it's
gone
got
again.
He's still
signal.
there.
No,
He's
it's
still
gone.
there. I think he still
Sorry,
has
guys.
signal
I seem to
connection.
have a.
Yeah, we hear that.
Sorry, guys, I had a bad connection there. Can you hear me at the moment?
Yes, we can hear you.
Yes.
Oh, perfect. I love technology when it works, and it just dropped me out there saying, "Oh, we're trying to reconnect you." Oh, fun times, fun times. All right. So did you guys hear the answer for that one?
No, we didn't
No,
I
we
got the
didn't.
answer for this one.
Okay, perfect. All right, so A is indeed the correct answer. So I know a whole lot of guys in the chat are super, super happy, and it is indeed A. What happens is we cleave the states in half, and then it goes through each parent. There was actually a question where someone asked this specific thing. So this is how you would indeed do it. So next question so long. Right, so this one says, divisions in a will contains a nudum preceptum. Select one. My son jointly during his lifetime. Option B is I leave my farm to my son Sam. He leaves South Africa permanently. If he leaves South Africa permanently, the farm must go to my brother Ben. Option C is I leave my farm to my sons Charles and Peter. If one of them cannot inherit, my brother Dirk must inherit his share.
I can't see your question, Darren.
And option
Yeah, I
Mary
was
may live
wondering
on the
that
farm until
because I
her
can only see the previous
death.
question.
Perfect.
Can't you guys see the question there?
No, it's appearing now.
It's appearing. Oh, okay. All right. So I'll give you a moment to go through the question, and then we can see which one. So I know we only very, very, very briefly touched on this particular topic, but I don't know if anyone perhaps remembers or reading it in the prescribed book. Any takers? Sean, I'm not sure if you are back with us yet at all or not. That looks out okay. Hey, we've got a hand up. Go for it. Which one do you think it is?
I'm gonna guess and say option A.
All right. Option A. Interesting. Non-Kuleka?
Also option A for me.
Non-Kuleka? You'd have to ask. You've unmuted it. Which option do you think it is? All right, I see we've got quite a few A's and a couple of brave B's. Malozonga? Oh, geez. You'd have to pronounce your name for me so that I can pronounce it properly.
Okay, it's my surname, but my name is Sebulele, Sebu for short. So I think it's A. I think it's A because it says John may not leave the farm permanently during his lifetime, but then there's no substitute if John should leave. So whether he does leave or not, it would still remain with him, the farm that is. the farm will still remain with the son John, even if he should leave, because now he's not saying if he should leave, then it would go to my brother and stuff like that. So I think that's the
100%
concept
spot on.
nudum praeceptum. Yeah.
Yep, spot on. You get stars, you get for 100% spot on. So the reason it's option A is because even if John did leave the farm, there's no alternative to take place. So in this case, it's like a void, I suppose, condition, because there's nowhere for it to go to. I see we've got a hand that just popped up now. Do you have anything to add for us? Oh, that's gone. All right, we'll have to give you first dibs on the next one. So the next one is, oh, this is quite a long one on that side. You might have to zoom in on it. The question is, Xander and Wendy were married out of community of property. Ooh, remember those things, eh? Out of community of property. They had 2 children, Anna and Ben. Anna died in 2005, leaving her 2 children, Dion and Ethel. Xander died interstate in 2023, and he left behind his wife and children and grandchildren mentioned previously. His estate amounts to 600,000 Rand. How much will a child's portion be? So a child's portion is equal to all the children plus the spouses. You take that number and then you divide it by the estate value. So in this particular case, what would a child's portion be? Well, we see a couple of options B in the chat. Kundai, go for it. You want to give us a reason too? Yeah.
Okay, so my network is really not on my side today. I don't know if I'm audible. Am I audible?
Yes, we can hear you loud and clear.
Okay, perfect. So the child's portion, I'm gonna go with option B, since there's the surviving spouse, Wendy, and there is 2 children. However, with Anna, she did leave descendants of her own. So it will be 600,000 divided by 3. And then the descendants, the grandkids, can divide the 200,000 amongst themselves. However, the child's portion is 200,000. That's my final answer.
All right, 200 it is. So that is option B. Which in the chat there seems to be, I think, an overwhelming majority of B's in the chat as well. Nonkoleko, I see your hand is up again. You'll have to unmute your mic if you want to chat. I'm not sure, maybe your hand is going up by mistake. But if you do want to chat, you'll have to unmute your mic. Right, so all those who chose option B, you guys are all 100% right. And Kundai gets an extra gold star because she had the reasoning behind it as well. So I see there was a lot of B's. So B's, you guys won. D's, you were just off the mark there a little bit. So when we calculate the child's portion, we haven't worked out the spouses section yet. So that 250,000 we don't count yet until we've worked out the child's portion. Once we've worked out the child's portion, we can then start taking off what that spousal amount. So in this case, because the child's portion is less than the statutory, the spouse would get. Spouse would get 250,000, and this won't get a child's portion, so you'll take that full 250,000, which leaves us with, what's it, 600 minus 250, it leaves us with 350,000. That 350,000 would then be divided out amongst the 2 children. Obviously, Anna, because she's died, her 2 children would inherit that portion that was given to her. Right, here's our next one. Oh, this one shouldn't be too bad. Doesn't look too long. So
Darren, can I please come in?
Sure. What do you have?
On the previous question,
Yes.
you are saying the spouse will get 250,000, and
Yes.
then what will be left is 350,000. And
Yes.
then on the 350,000, you will have to divide it by 2, which will give
That's
you
correct.
175,000 each. And here we're
Yeah.
speaking of 200,000.
Okay. You want to know where the 200,000 comes from?
Yes.
All right. So when the question is specifically asking us what is a child's portion, so in order to
Yes.
calculate a child's portion, we take the full estate amount, and that's going to be divided by the number of children plus the number of spouses. So
Okay, yes.
divided by 3, it gives us 200,000. So we only do the child's portion to see, does the spouse get the 250 limit, or does she get a child's portion? Because you, excuse me, because sometimes let's say this was too much to say that the spouse gets the child's portion, but in our particular the limit that the spouse is allowed to take, they'll take the 250 for the spouse, and then whatever's left over will be divided out. And as you rightly pointed out, we'll be left with 350. And because we had 2 children, Anna and Ben, each one would get the 175,000. But because Anna, that 175,000 would pass to her children. Because she's got 2 children, that 175 would be divided in 2, and then each of her children would get half of the amount. Whereas Ben, because he's still alive, he would get the full 175.
Right.
But in any case, we know that's how we get 200,000, and that's how we get the 350 that was left behind.
Noted.
All right. I'm going to assume it makes sense. I don't see any. Okay, perfect. All right, as follows. I leave my house in Pretoria to my daughter Delilah. If Delilah dies without children, the house goes to my brother Bandili after his death. The question 2A, the sub, and we've got 4 options. The first one is a direct favor of Bandili. The second one is a video commission tacitum in favor of Delilah's children.
Please share the question, David.
Third option is a modus, and the fourth option is an usufruct in favor of Bandili. Now, I had a need. Sorry.
I was saying, please share the question on the screen.
I asked a question. All right. Okay, so my knee-jerk reaction was. Sorry, who's speaking?
Is Juliet speaking? I was saying, please share the question
Hello,
on
Juliet.
the screen. Okay. Perfect. Can see
Is it
it
not
now.
showing? Let me stop sharing and then reshare it. I've just reshared it now. Hopefully it does show up. Okay, so as I was saying, I had a knee-jerk reaction to a particular thing. I thought, hey, that's it there. And then I was like, oh, it took me for a sidewinder there, because the initial one wasn't actually the one. I had to look this up in the book just to like make sure that I was definitely wrong. Anyway, I'm not going to pronounce your name there. I don't want to mess it up, but go for it. What's your answer? Kurhula? If I'm pronouncing your name right.
Hi, Darren. So yeah, no, it's fine. You won't get it right unless if I tell you it's fine.
My answer
Go back
is
to it.
B because
So
hello, can
you
you
just
hear me?
hold on? We've really got someone who's speaking. If you can just wait a moment, please.
I'm sorry, I'm gonna take you back. It's in regards to the previous question. Yeah, my hand was up before we could even come here. It's just that you didn't see. I get confused. Can you just please make me understand?
if you can maybe give us
I'm not sure if it's my network or your network, but I'm battling to hear you.
Yeah, his network is not
all right.
okay.
I'm just saying I've got
Without children. What else?
sorry guys, are you able to hear me now?
I can hear you on my side. I can hear you on my side.
Is it perfect?
Yes,
I know
yes,
someone was
yes.
saying that I was dropping out, so I'm not sure. It's probably a bad network on my side. Shouldn't be, but you know, technology. You were
Yes.
saying you thought the option was?
No, I thought the answer, based on my calculation, my answer was 175,000.
Oh, for the previous question.
Yes, for the previous
Yes.
question. Like I get confused.
Okay, yes. So the
Like
previous
I don't know
question
when,
asking,
yeah. Some of the
let me
examples
just
that
move
have
back.
been sorry, okay, you can come in.
Now, I was just going back one now. So the one that's shared now should be the example you're talking about with regards to the child's portion.
Yes.
Okay. Right. So the 175,000 is correct with regards to what the children would get. But this particular question was asking what the child's portion would be. So the correct answer for this question would be the 200,000. But if they asked us what was the amount the children got, you would be correct with the 175,000.
Oh, okay, okay. I think I get it. So the trick is the portion.
Yeah, you've got to read which particular thing they're asking. So in this one, they're asking us what is the child's portion, but they could quite easily have asked us what does each child get, in which case you would have been spot on.
Oh, okay.
All right. So
Okay.
let's move back to the Teddy question now. Did anyone perhaps know which option this would be? Oh, I see we've got a hand up already. What do you think the option is? Kay Rakati, you've got your hand up.
Yeah, I was saying I think the answer is B.
All right. So we've got a B.
Yeah, because the tester gives to a first legate with a provision that on a future event, the property must then go to a secondary beneficiary. That is classified that answer.
All right. I like it. Who else wants to try out? Juliet, I saw that name come up very quickly.
Yes, I think the answer will be A because it's the in terms of the will, it says that the house, in an event if Delilah dies, it goes directly to the brother Bandile after the death of Delilah. So it's a direct substitution in favor of Bandile because he'll be the one who'll be inheriting the house after the death of Delilah. Thank you.
All right. Perfect. Mr. Peng?
Thank you very much, Darren. Yeah, actually, I support the answer B because, in essence, the idea of the term fiducial commission, TESM, they should be in favor or they should actually remain in the same family or family name. Thank you.
All right. Yep, no, it makes sense. All right. So before I give the answer that was on, does anybody else want to have a jump in there, like last chance? Going once, going twice. Check. Hey, Kundai. Hey, you know how to nail it under the hammer.
I'm sorry for that. So yeah, I'm gonna support option B as well. Fide commissum tacitum. So tacitum means silently, and this presumption will only apply if, like, to the example that is before us right now, if the bequest is to the testator's own child. I don't know if I'm making sense. But then, yeah,
Yep, no,
since
that makes
it is
sense.
Delilah, that's the testator's child, then her kids would have to be next in line to inherit. That's the presumption. Thank you. I'm done. Thank you.
Yep, 100%. I see you're able to convince some people because they're changing to be as which is the Fide commissum tacitum. As I mentioned, when I first saw this question, my knee-jerk reaction was like, oh, it must be A because it's a direct substitution. But a bit more thinking in what it turns out that there isn't tacitum here with regards to who should be getting the house, which is Delilah. Hence, if she our children should rather go to somebody else in the family. Answer for this particular question, just because it's got that implied intention of handing it down in the family. So, yeah, this one that boggled the mind for a moment. Ooh, who wants to do numbers? Guys, or do you want to skip to the next one? I don't see any hands saying skip, so let's have a go for it and see how we can work some numbers out. Can you guys see the screen that I'm sharing? I just want to make sure we haven't had a technical glitch. All right, okay. Okay, so this question says that Tom, who died interstate in October 2023, was married.
Darian, we're still on the last question.
Yes.
So the last question was B.
All right, let me just unshare and then reshare.
Yeah,
There must have been a little glitch. Right, hopefully you guys can see that window with the new question. Can everyone see Tom? Or is Tom still not around?
No, it's very clear. We can see it now, Darren. Thank you.
Awesome. Okay, so Tom, okay, he died in 2023, married in community of property to Wendy. They had 4 children, Ayanda, Bongani, Carla, and Dumi. Ayanda had 3 daughters, Eve, Fiona, and Tara. Eve died in 2015. Carla, who died in 2010, was survived by her son, Sia. Tom and Wendy's joint estate is worth 1,600 or 1,600,000. How will Tom's estate evolve? Now, I'll give you guys, or devolve, I'll give you a couple of minutes to work this out because there are some numbers involved. So I'm going to give you a moment to think over those numbers because you will have to calculate this. It is a basic calculation, but you will have to do some number crunching. Whenever you're ready, you can pop your hand up or you can type it in the chat box and then we'll see what is what. I hope you brought your snacks. Oh, hey, Kundai, hey, you haven't even had a chance to have snacks yet, have you?
I haven't had any snacks. Sorry.
Oh, awesome. Go for it.
So I am going to break this down. I hope it's okay with everyone.
Yeah, go for it.
Okay. So Tom, who died interstate October 23, was married in community of property to Wendy. So they had 4 kids. So with the 4 kids, there's one who's predeceased. No, there's one who's adopted, which is Carla. And Carla is also predeceased, but was survived by her son, Sia. So whether she's adopted or not, it does not apply. She or he, is it a he or she? She is
It's she.
yes, she is going to inherit still, whether she's adopted or not. So I have 4 kids plus the spouse, Wendy, that makes it 5. And the second part, when I'm gonna deal with the joint estate. The joint estate of Tom and Wendy amounts to 1,600,000, which means Wendy is entitled to half of that estate. That is 800 rand. So I'm 800,000 rand. Sorry, I'm already gonna remove that and set it aside. And the final question, which is how will Tom's estate devolve? So Tom's estate is amounting to 800,000, and I'm gonna divide that by 5, which will give me 160,000.
All right.
Pretty sure it's 160,000. Yes, and so it's less than the child's portion that a surviving spouse is supposed to get, which is the 250. So here my option, I'm gonna go with option C as my answer, where Wendy will inherit 250,000 and Ayanda, Bongani, Dumi, and Sia will then each inherit 137,500. Yeah,
You'll
the
have some
numbers are
very
getting
upset
to
people
me,
with you.
sorry.
Right, so that is option C. Yeah. Right. I actually like the explanation. It was very well rounded. So does anybody have anything to counter that very well reasoned calculation and layout? Okay, I see in the chat we got quite a few A's, a very brave D. All right. Okay, so the answer in this case is indeed C, exactly the way that Kundai worked everything out for you. Irene, go for it.
Hello, Darren, can Kundai please explain? I don't understand why we went to 250. Can she please explain that? Maybe I will understand it, because Wendy was to get 800,000, but immediately it went to 250. Can I understand the 250?
Okay, perfect. Kundai, do you perhaps want to explain it to them? Or do you want...
Okay, so I'm gonna try to explain it, but then you're gonna have to come in and help me with that. So the 800,000, Tom and Wendy's joint estate was worth 1,600,000, right? And then we have to remove half of Wendy's share, which is 800,000, since they were married in community of property. So Wendy is entitled to half of the estate, their joint estate. So the question here is asking us, how will Tom's estate, the remainder of the amount, the remainder of the 1,600,000, how will Tom's estate, which is 800,000 after removing Wendy's estate, Wendy's share of the estate, how will Tom's estate devolve? So I have 800 rand. This is 800,000 rand. Tom's estate. Are you guys following?
Yeah.
Okay, 800,000
Yeah.
rands. Tom's estate, right?
Yes.
Okay, divided by 4 of his kids and his surviving spouse. That makes it 5. Remember, we're including Carla because Carla has a child.
Adopted.
Yes. Okay, so divided by 5, right? Sorry, guys. Darren, can you take over? I'm really sorry.
No,
I'm trying to.
no
My
problem.
network is bad as well.
No, 100%. Hey, Kunda, you were spot on there. All right, so I think what Kunda was also trying to emphasize is that you were asking about where does the 250 come from? Where does the 800 come from? So it's actually two different estates. So remember when we were doing family law, when you married in community of property, the marriage dissolves on death. So in this case, they've got 1.6 million in a joint estate, but we've got to divide that now. Because it's community of property, Tom gets 800,000 and Wendy gets 800,000. So Wendy gets to pocket her 800,000 because that's from the joint estate. So that's hers to keep. We now put that aside and we forget about that 800,000. What we're worried about now is Tom's 800,000. So Tom has died. So his 800,000 has to devolve on someone. So first thing we have to do, as Kundai was saying, is calculate what is the child's portion, because we have to decide now, does Wendy get the 250,000 that she's entitled to by law, or does she get the child's portion because she gets the higher of the two? So if we take 800,000 and you divide it by 5, it's by 5 because we take the 4 children and the spouse, that makes 5. That gives us 160,000. Now, 160,000 is less than the statutory amount that Wendy's entitled to have, which is 250,000. So what will end up happening is Wendy's entitled to the 250,000 and we'll give that to her. Now we've got to say, well, how much is left to hand over to everybody else? So we take the 800,000, we minus the 250,000, that leaves us with 550,000 for the 4 children. So because there's 4 children, remember we have to give some to Carla because even though she was adopted by law, she is one of the children. And although she is deceased, she did have children. So her children by substitution will stand in for her. All right, so we've got 550,000 left now after we've given Wendy her 250. We take the 550 and we divide it by 4. That means that each of the children is going to get 137,500 Rand. But because Carla is deceased, her children, Eve, Fiona, or Eve has died, so it'll be Fiona and Tara, they must share Carla's portion, which is 137,500. So if you look at the Ayanda Bangani, where's it, CR1, let me just see which option it is, you'll see that it's 137,500 and then the others get to share. Let's see, where's it? 250. Does that make more or less sense with how the numbers are calculated and why Wendy keeps her 800,000 plus she gets from Tom's estate?
Yes, Darren, I think the thing that I didn't understand was the spouse in this case, she benefit twice from the joint and from as a child and as a descendant again. So thank you very much for clarifying that to Gundai as well. Thank you so much for your explanation.
Yeah, awesome. Gundai was doing an awesome job there. So if it wasn't for the network, she would have gone all the way. Ketcha, I see you got your hand up. I hope I'm pronouncing your name right.
Okay, thank you, Darren. Okay, I just wanted to say because the lady was asking about 250,000. We must also not to forget to mention that 250,000 is a statutory amount that a wife is supposed to get. Thank you.
That's correct. No, 100% you're spot on there. So when we're working out what the spouse gets, the 250,000 is the statutory amount. And if the child's portion is less than the statutory amount, then they will get that statutory amount. But if the child's portion was higher than the statutory amount, then the spouse would get the child's portion. So that's why we start with that calculation first. So yeah, you guys are all spot on 100%. Hey, see, calculations are easy. You guys are going to nail this. I see we are almost at 9 o'clock. So maybe let's do another question. We'll squeeze it in before we get to 9 o'clock. So those that need to leave will be able to leave, but let's try one more quickly. All right. So the new question, hopefully you guys can see, it's asking about testamentary writing. So a testamentary writing is defined as a document that, and our first option is A, complies with the formalities for a valid will. Option B is contains the testator's signature. Option C, describe the three essential elements of a bequest, namely the property bequeathed, the extent of the interest bequeathed, and the beneficiary. Or option D, describes any one of the three essential elements of a bequest, namely the property bequeathed, the extent of the interest bequeathed, or the beneficiary. And hey, Kondai, I see your hand is up, sharp. Which one?
I am gonna go with option D.
Awesome. Option D. Let's see. Let me just click over to the chat quickly. Oh, Fikili made an awesome calculation there I see in the chat. Oh, it shows exactly how to work out the child's portion. Awesome. Let's see. Ah, no C, and a D. It seems to be quite over. All right. Anybody else want to perhaps have a go at it before I tell you the answer? Oh, we've just got an A from there. Right. So the answer in this particular case is actually option D. So option D is because we're talking about testamentary writing. And if you remember, testamentary writing is when we talk about one of those three elements. Was it a photograph, for instance, identifying what the object is? Was it talking about who the person it is? Was it talking about the ownership? Is it an usufruct, a fideikommission, etc.? So testamentary writing falls in the same category as a will, but it isn't a will. So just be careful of that sneaky little definition. You know the law, everything's turning on all these little words. But yeah, awesome. I'm not sure if you guys want to do any more questions. I have a couple of more if you would prefer to call it a night. I do know we've gone a little bit longer than expected, but it's up to you guys. I'm not sure how you guys are doing for time.
I don't mind proceeding. I don't know about others.
All right then. All right. So, okay, let's call it a night for those that do need to go. And if you can stay, awesome. You can stay with us and maybe we'll go through, let's do maybe another 4 more questions, and then we'll call it an evening. But if you do need to leave, it was awesome having you here. If you can stay, that'll be even better. But otherwise, you are free to carry on with your evening. For those brave souls who are staying behind for some more torture, let's load up another question. Oh, this is going to be a short one. This is going to be easy, man. So this question says, the moment when a beneficiary obtains a vested right to claim delivery of a bequeathed property unconditionally is called, and we've got dis venit, dis sedit, an unconditional bequest, or a time clause. Now, if this was the actual exam and you weren't 100% sure, I'd knock off the 2 that I know don't fit into this category, and then I'd probably work out what the last 2 were. Take an educated guess, so as to say. Does anyone want to perhaps try their luck and see? Oh, we've got someone saying a B. And we've got a brave A there. All right, so you guys seem to be on the roll. I'll knock off. Okay, so it's not option C and it's not option D. We only have 2 options. You're either in A camp or you're in the B camp. Ooh, the B camp just gained a few more followers. All right, so we're going to do this like going once, going twice. And the correct option is everyone in the B camp. So if you look up the wording that they've got for a decided, the wording they use there is unconditionally. So that would be the correct option here. Let's go to the next one. Oh, interesting. Right, so in 2023, Thomas, a very frail old man, made a 1-page will in which he left his estate to his children. Thomas signed the will with his mark in the presence of 2 witnesses and his attorney, one Johnson. The witnesses signed the will with their signatures immediately after the testator had signed the will with his mark. The attorney, Johnson, then signed the will and wrote the certificate required by Section 21A at the top of the page. In the certificate, Johnson stated that the testator was known to him and that the will was the will of the testator. He then signed the certificate as A.P. Johnson, attorney at law. However, this will is invalid. And why is it invalid? So our first option is the attorney did not indicate his office as that of a commissioner of oaths. Option B is the attorney did not use the specimen certificate provided in the Wills Act. Option C is the certificate should have been attached immediately below the signatures of the testator and the witnesses and not at the top of the page. And our last option is D, the attorney did not follow the exact wording of section 2.1. I see we have a couple already going for A's, a lone D out there and a B. And A, go for it, Kunda.
I'm going to go with option A. Why do I go with option A? It's because Thomas signed the will with the mark. He used a mark. And the only time a certificate required by section 2.1a V is when a mark is used to sign the will by the testator.
All right.
Thank you.
So that's option A. Ah, we've got a couple of C's now and an A. Oh, we're going like shotgun now. Anybody else want to try out? We've got another one for A. All right, so going once, going twice. The correct answer is A. The reason that A is correct is because the attorney didn't actually state his office as being a commissioner of oaths. According to the prescribed book there have been cases where a will was invalidated because on the stamp it didn't say that the capacity was the commissioner of oaths. So they actually have to say on there commissioner of oaths. So yeah, go for the A camp. It won again. Ooh. There we go. This could be simple. It's not very many words on this question. Typos. A valid will provides as follows. I leave my BMW motorbike to my friend Frank. Frank must pay 20,000 Rand to my brother Ben within 6 months of my death. The bequest of the motorbike to Frank is, and we've got some options here. Number A, it's subject to a suspensive condition. Option B, subject to a modus. Option C, subject to a direct substitution in favor of Ben. Option D, subject to a terminative time clause. So, suspensive condition, terminative time clause, direct substitution, or a modus. Let's see if there's anyone in the chat who's taking a go at this. We've got a couple of B's. Ooh, and a brave D. Hey, how's it, Sean? I saw a hand go up and then going down very quickly. Hey, Kundai. Being brave tonight.
Feeling very brave tonight. I'm going to go with option B.
Option B.
Yeah,
modus.
I'm going to go with option B. Why? Do you mind me explaining? Sorry to cut you off.
No, go for it. I'll give you an extra gold star.
Okay. So modus, what I know about a modus is that the beneficiary, the one that's actually inheriting from the deceased will, can choose to not go ahead with what's been stated in the will. And here it says Frank must pay 20,000 to my brother within 6 months of my death. I don't think it really specifies that. Well, my keywords which I was looking for were if he does not pay that, then this and that will happen. And I don't see that. So I assume it is subject to a modus.
All right. I see we've got a couple more for B as well. Anybody else want to try their luck at this one? All right, so the correct answer is B. The reason that it falls under a modus and not one of the bequest options is because when he was bequeathed the BMW motorbike, he got the ownership, so the decedent and disvenant all at the same time, so it belongs to him. There's no suspensive clause, there's no resolutive clause. That motorbike belongs to him. However, it's a modus because there's been an obligation imposed on Frank. So because Frank accepted this benefit, he now must pay Ben 20,000 Rand. This would have fallen under a conditional bequest if he didn't get that des venant now. So it would have been a suspended one, but that's not what happened here. He got a decedent and des venant all at the same time. So he has ownership over that vehicle there and then. There's no delay or anything along those lines. So this falls under a modus because there's still an obligation that he has to fulfill. In this case, it's the 20,000 Rand. And because it's a modus, if Frank doesn't pay that 20,000 within 6 months, Ben has a personal right of action against Frank. So he can take Frank to court to pay back that, or to pay that 20,000, because it was one of the obligations as part of the will. Right. Let's see. Question. We'll do this as our second to last question, I think. All right, so Tando's valid will contains several legacies. In the last clause, the will provides as follows. The residue of my estate I leave to my children Dumasani, Carol, and Corneli in equal shares. The bequest of the residue of the estate to the children is known as A, an inheritance, B, a legacy, C, an accrual, or D, a pre-legacy. So who thinks it's which? So a legacy is when you get given a particular asset. So you might say, well, I bequeath my car to my friend. That would be a legacy. If you say, you know, I want this person's legacy to be paid out first before everybody else, that would be a pre-legacy. So who thinks this particular one is one? Let's see on the chat. So on the chat, we're going with A's. We've got inheritance. Okay. We've got a hand up. Irene, yay, go for it. You'll just have to unmute your mic, Irene.
Sorry, Darren. I was going to say I'm going with the option A because it is not mentioned what kind of benefit they must get. It just says they must benefit. So it's inheritance.
All right. Let's see what's happening in the chat. Oh, we've got a couple more for H. Sure, it looks like A is winning hands down, yeah. A couple of brave Bs, but seems to be mostly A. All right. Anybody else want to have one last thing before going once, going twice, 2 2/3, and the hammer's done. Okay, the answer is indeed A. And the reason it's an inheritance is it's the residue of the estate. So if you look up the definitions that they've got for these particular ones, they class this as an inheritance. So spot on, the A camp, you guys get yourselves another gold star. Let's do one last one, I think. Oh, interesting. We had a couple of questions for this. Or actually not this particular one, but anyway, a deceased descendants do not include the following. So our options are A, a woman who was involved in a substitute marriage or a woman-to-woman marriage. Option B, persons in the collateral line such as brothers or sisters. Option C, a person who, during the lifetime of the deceased person, was accepted by the deceased person in accordance with customary law as his or her own child. And our last option is D, persons in the downwards line such as grandchildren. So now the question is, which are not the descendants of the deceased? So we're going to be very careful that word there, not. So I see, Kundai, I see your hand up. What do you think it is?
I'm going to go with persons in the collateral line, such as brothers and sisters, option B.
All right. Let's see, we've got a couple in the chat here up. B seems to be the favorite. Come on, guys, this is our last question. Come on, squeeze it in. Who wants to have their last and final say? The chat definitely B's. Oh, we got a brave A in there. So B seems to be winning, but we do have a brave A. All right, and the answer is option B. The reason it's option B is your collateral line is not your direct line. So if you remember from the law of persons, your direct line will be your ascendants and your descendants. Those who are on your collateral line, that's your brothers, your sisters, your cousins, etc. They are on your line next to you, so they're not in your direct line. So yeah, awesome. You guys were nailing those ones down. I think overall we all got distinctions tonight. So I'm going to take that as something good come Tuesday. I'm definitely looking forward to Tuesday. I'll have a bit of time after Tuesday to have a break between then and the next exam. But you guys did awesome tonight. Unfortunately, we did run out of a bit of time. We had a bit of a time issue, but hopefully there were enough pointers in there to get you going in the right direction. Do try out the mock exam. If you find any mistakes, I know someone put one up there where the options were options. So that's kind of scary. But I mean, if you do see any mistakes, do drop me a message. Otherwise, hopefully that will also go towards your practice time. Before we close for the evening, does anyone have any last minute questions, comments? Is there anything you want to say before we close for the evening? It doesn't look like we have.
Hello, Darren, maybe we should just thank you for making time. We really appreciate that. Thank you very much.
Oh, that's awesome. I appreciate spending time with you guys. I always find, especially the last part, fun. The presenting part, I mean, it's good. But the question side, this is the fun side where we get to do all these cool things. And I think that's also where we learn probably the most, because we've got skin in the game now. We've got to make a choice and we've got to stick with our choice. But yeah, it's been fun, guys. I enjoy spending time with you. But I think let's call it an evening now so we can go spend some time. I need my cup of coffee. And yeah, at least we can have Sunday off, half Sunday, because we've got to practice for Tuesday's exam. Don't forget to brush up on the cases as well. I've seen a number of questions in the mock exam where they do ask about cases, so don't neglect those. Juliet, I see your hand went up.
Yes, just want to appreciate, especially with the calculations of the estate, and with the previous speaker who was unpacking it, how to calculate it, really assisted to appreciate that. Thank you so much.
Yeah, Kunda had those calculations done for a
yes, Kunda.
Sorted.
Yes.
You're welcome.
Just unfortunate
You're welcome, and good luck.
Thank you.
Oh, awesome, guys. Yeah.
I think the question of calculations pop-ups in the exam, the manner in which Kunda has explained it will definitely get a mark.
No, 100%. So yeah, it was fun, guys. We'll call it a night now. I'll see you over in the WhatsApp group if you have any other questions or if you just want to chat. Otherwise, enjoy your evening. I will upload this video to YouTube shortly, but obviously my network at the moment seems to be coming and going. But I'll try and upload it tonight, and hopefully at the latest by tomorrow morning I'll be able to share it on the group for you. But yeah, it was awesome. Enjoy your evening, and I will see you guys over on the WhatsApp group.
Thank you, Darren. Thank you, everyone. Bye.
See you, Irene.
Thank you.
Thank you, Darren. Thank you.
Bye.
All the best, everyone.
You said that.
Thank you. Bye-bye.
Bye.